All right, let's talk about something you probably do every single day in your practice: writing medical certificates and disability letters. We're going to focus on a really crucial aspect of this: how to avoid making false statements, and most importantly, how to reduce your medical legal liability. So let's be honest for a second. When you sign a medical certificate, do you see it as just a helpful document for your patient, or could it actually be a legal liability waiting to happen? Think about the last one you signed. Was it just, a routine piece of paperwork? Because the truth is, that simple document can turn into a huge legal problem. It's something every single one of us doctors really needs to think about. Okay, so where do these risks actually come from? Well, to really get it, you have to know where your certificates end up after they leave your office. It's not always where you think. Let's take a look at the journey these documents take, because believe me, the stakes can be incredibly high. You see, that piece of paper you wrote isn't just for getting a day or two off from work. No, it can end up in some very serious places. We're talking about court proceedings, where it becomes actual evidence, or in nasty employment disputes. It can be the key document for huge insurance claims, or the reason someone gets academic accommodations, or even long-term disability benefits. The context is everything. So what's the bottom line here? It's this: every single certificate you sign has serious medical legal weight. It's not just a medical note, it's a potential legal weapon. You've got to assume that every word will be picked apart by lawyers, by judges, by tribunals. It's that serious. And if things go south, well, the consequences are genuinely career-altering. I'm not talking about a slap on the wrist. If you issue a false or even a misleading certificate, you could be looking at disciplinary action from the NMC. We're talking criminal charges under the IPC, civil lawsuits where you're paying damages out of pocket, and, in the worst-case scenario, the suspension or even total cancellation of your medical registration. It's a scary list. Okay, so that's the scary part. The big question is, how do you protect yourself? How do you walk through this legal minefield? It all comes down to building your practice on a really solid legal and ethical foundation. Let's break down the core principles you absolutely have to follow. Now this right here is the golden rule. It is 100% non-negotiable. A certificate has to be based on a direct personal examination of the patient. Let me be crystal clear. You cannot, and I mean cannot, issue a certificate based on a phone call, or a request from a family member, or just because you think you know the patient. It must come from your own two hands, your own two eyes, and be backed up by solid clinical evidence that you wrote down in your notes right then and there. Okay, look at this. This is a perfect example of how language can be your best friend or your worst enemy. On the one hand, you have the high-risk way. The patient definitely cannot work. That's a huge, absolute statement. How can you prove that? You can't. It's almost impossible to defend. Now look at the low-risk version. It's so much smarter. You say, based on today's examination, so you're tying it to a specific point in time. You say the patient reports pain, and you observed a limited range of motion. You see, you're separating subjective from objective. And then you wrap it all up as, in my clinical opinion. It's an opinion, not a guarantee. That is so much safer. Right. So with that in mind, let's actually build a safe certificate from the ground up. Think of what's coming next as the essential blueprint, the anatomy of a document that's legally defensible. Every safe certificate you write should have these 6 essential parts. It's like a checklist. Number 1, your ID. Full name, qualifications, registration number. Number 2, the patient's ID. Name, age, sex, maybe an ID number. Number 3, and this is so important, the exact date and time of the exam. Number 4, your clinical findings. Remember, what you saw versus what they told you. 5, how does it affect their function? Are they fit for work? What are their limitations and for how long? And finally, number 6, your reasonable medical opinion using that cautious professional language we just talked about. All right, so we know what to put in. Now let's talk about what to leave out. These are the common traps, the red flags that you need to avoid at all costs. Okay, this is a big one. A really common mistake is mixing up a medical certificate with a disability certificate. They are not the same thing. Not at all. A medical certificate for, say, sick leave, any registered medical practitioner can issue that. But a disability certificate, that's a whole different ballgame. It's a specific legal document, and it can only be issued by designated government authorities, usually a medical board, after a formal assessment. So whatever you do, don't issue something you call a disability certificate unless you are specifically authorized by the government to do so. You've got to be so careful with your words. Here's a simple rule. Avoid absolute terms. Words like 100%, permanent, or guaranteed. Look, we're doctors, right? We know medicine is about probabilities, not certainties. The minute you use a word like permanent, you're creating a standard that's almost impossible to defend in court. It just makes your certificate incredibly easy for a lawyer to attack. Now, let's be extremely clear about this one. Backdating. We've all been there, right? A patient asks you to backdate a certificate for them. They'll say it's just a small favor, but the answer has to be a firm no every single time. Backdating isn't a harmless favor. It is professional misconduct, plain and simple, and it comes with serious legal penalties. The date on the certificate must be the date you actually saw the patient. No exceptions. This is all about staying in your lane. You are an expert in medicine, not in law or human resources, so you should never, ever certify non-medical facts. Don't write about the patient's character, don't give an opinion on whether their workplace harassment claim is valid, and definitely don't try to determine who's legally responsible for an injury. Just stick to the medicine. Stick to what you know and what you can prove. Okay, so we've looked at the dangers, the right way to structure a certificate, and what to avoid. Let's wrap up with the most practical stuff, the exact words and phrases you can use to protect yourself and seriously soften your liability. Think of these phrases as your protective toolkit. You should use them all the time. Based on findings on the date of examination, that locks your opinion to that one specific moment in time. The patient reports. Perfect. That immediately tells everyone this is what the patient told you, not what you discovered. In my clinical opinion, that frames everything as your professional judgment, not a statement of absolute fact. Seriously, these aren't just phrases. They're like a legal shield for you. And just a final point on process. Remember, your job isn't over when the patient walks out the door. The documentation is everything. You need good, clear notes from the exam itself. Give the original certificate to the patient, of course, but you absolutely must keep a secure copy for your own records and make sure it's linked to their clinical file. That little bit of diligence today could literally save you from a major headache years from now. So when you boil it all down, what's the most important thing to remember? It's actually pretty simple. Your best defense isn't some complicated legal trick. It's clarity, it's objectivity, and it's caution. It's the care you take every single time you put your name and your registration number on that piece of paper. Your MedLawyer, protecting doctors, empowering patients.